Actually, this is perfect. I would be very, very worried if I walked in here and there was dead silence. That's not a good sign. So the very fact that a group of interested and committed citizens and friends and colleagues are having a great conversation, and based on what we have already seen and heard already today, I can't think that you wouldn't be having a conversation in some form or another. You'd have to be absolutely heartless not to be talking and engaging. And my gosh, what we've seen today has just been very compelling, with David Sheffer's fascinating discussion, along with just getting this review of the field by all of the world's current chief prosecutors and their representatives, telling you exactly what's going on to prevent the kind of things that you saw with Andrew Cayley in improving. You know, you have to go into court and prove it. We can say a lot of things like crimes against humanity, but someone's got to go in and actually say a crime against humanity has been committed at this place. These numbers of people have been destroyed. And I thought that that was incredibly important for us to kind of just reflect on that, because I think what also Andrew brought out, and we tend to forget this, even though those of us that have been in this business and have done this, we tend to forget the victims. It's one human being at a time. These were you. And I think that that also kind of resonated with all of us, I think, a little bit today. We don't want to go overboard, but I think it made us pause to think that, one, we're blessed. Two, the law is more powerful than the rule of the gun. We're making steps forward. Maybe it's 2 steps forward, 1 step back at times, but really we are moving forward, and mankind has committed that we're not going to let this happen again. We may not be politically motivated to do something, but we now have the capacity procedurally, legally, jurisprudentially to, in fact, seek justice for victims of atrocities such as we saw today after lunch at Srebrenica. Well, I would love to do that, but unfortunately I have a colleague that is going to be a little bit shorter than I am. I don't want to touch it, but bear with me. If I do this, then we got to do all kinds of things. Can you hear me? Okay, all right. All right, well, this is Chautauqua, and I get it. All right, can you hear me now? No. All right, well, what's that? How's that? Well, I'm not going to do that. I probably wouldn't be able to get back up again. All right. Well, crimes against humanity is what we're thinking about, discussing, considering, and of course, it's more than just the actual crime itself and proving the crime and going out and bringing in those who commit these horrific acts, but also to move forward and how do we, in fact, stop this from happening. And so what we're going to do today or this afternoon is discuss a very important initiative started by our good friend and colleague Leila Sadat and a group of experts such as Bill Schabas, and they'll be talking about the Crimes Against Humanity initiative. And Leila, I'll just turn it over to you.
This is why we had the microphone down low.
I'm a prosecutor, not an electronic guy. You got it?
Yeah, thank you. No, that's great.
Oh, good.
Because Bill is going to actually speak next, and then we'll have to move it again. Can you hear me? Yes, okay. The higher registers maybe carry. So it's so wonderful to be back here at Chautauqua. And every time I come, this is my 5th time coming now, and when I get to that hill where you can see down the street and you can actually see Lake Chautauqua, I have this feeling that I'm coming home. It is just a beautiful place. All of you, the Chautauquans, have created this beautiful space for conversations like this. And it's such an honor and a privilege to be here. It's also a little humbling because my good friends and colleagues, David Crane and Greg Peterson at the Jackson Center, and everybody who makes these dialogues possible are so accomplished and so modest at the same time. And to follow Andrew Cayley's extraordinary, and let me say it again, extraordinary presentation really takes some courage on my part, especially since I'm not very tall. But anyway, thank you so much for being here and for staying with us, because I think you'll find this afternoon's presentation well worth being indoors instead of out in the sunshine because we have a remarkable lecturer who's about to follow, William Schabas, and then I'm going to present the Crimes Against Humanity Initiative. So when David and Greg and Betsy Anderson of the American Society of International Law and all of us were getting together to organize this panel and these programs, we of course had other speakers who were supposed to fly in for this part of the program. And unfortunately, Hurricane Irene prevented them from doing so. So Bill Schabas and I are the last two people left standing or who made it here from our panel. And what we've decided to do is I'm going to introduce Bill, who's going to talk about crimes against humanity from a substantive perspective. Because even though we've talked about through all the prosecutors sharing their challenges, what's going on in their tribunals, how this is working, and we had that compelling presentation by Prosecutor Cayley of how to prove a crime against humanity, we haven't actually really talked about the crime yet in terms of what it is and how we address it. So Bill Schabas, who really needs no introduction, but I'm going to introduce anyway just a little bit. He is the former director of the Irish Centre for Human Rights at the National University of Ireland in Galway. And as of September 1st, he is moving to London, and he will join the University of Middlesex as a professor of international law, and is also a door tenant, did I get that right, Bill, at the Chambers of 9 Bedford Row in London. He holds many degrees, including several honorary degrees that he's received, I think, from Case Western and other universities. He has the Royal Order of Canada Medal. He's taught at the University of Quebec in Montreal, as well as the National University of Ireland and now Middlesex. He has published more than 300 articles in the field of international criminal law and several award-winning books, including a wonderful commentary on the International Criminal Court that just came out this year. His writings have been translated into several languages, including Russian, German, Spanish, Portuguese, Chinese, Japanese, Arabic, Persian, Turkish, Nepali, and Albanian. And those are probably just a few. So without further ado, please give a warm Chautauqua welcome to Professor William Schabas. Thank you.
I think that will do. You hear me there at the back? Yes? Can you hear me? I don't know what to do here. There we go. All right. Yeah. Okay, well, thank you. And as Leila mentioned, I've just moved from the tranquil west of Ireland to the big city in London. Being a specialist in the field of conflict and violent conflict, I felt I needed to get some field experience. And so I'm in North London now. Well, as Leila explained, our project and the theme of our panel this afternoon is the Crimes Against Humanity Convention, which doesn't actually yet exist, at least not in terms of a treaty that's been formally adopted and that is in force. It's a project that's making its way towards adoption. I think we launched it about 3 years ago, and we've been working on preparing a draft. And Leila will tell you more about that in her remarks. And the goal now is to get states to actually go through the process of adopting the text, and then a lengthy and complex period of ratification so that it enters into force and actually becomes a legally binding operative document. And so this is a long, it's an exercise that takes a considerable amount of time. And we're just part way along the road, maybe about a third of the way along the road. But like all ideas, it has to start with something. It has to start somewhere and with an initiative. And so that's what we've done. And the question that I want to try and answer a little bit at this point is why we need to do this. Because we already have a convention dealing with the crime of genocide. It's an old convention. It's more than 60 years old. It was adopted in 1948, in sort of the tail end of this very, very fertile period in the development of international criminal law, of which the Nuremberg trial is probably the centerpiece. And in fact, the Genocide Convention, which is formally adopted by the United Nations General Assembly in December of 1948, calls for the creation of an international criminal court in Article 6. So there's a trail here. There's a thread that starts, you might say, at Nuremberg or slightly before that, runs through the Nuremberg trial to the adoption of the Genocide Convention, and then brings us to this new period, because there's a hiatus there that's important, and that is another subject and difficult to explain. But between about 1950, 51, 52, the whole business of international criminal prosecution goes into a kind of hibernation, and it doesn't revive until the 1990s with the establishment of the International Criminal Tribunals for Yugoslavia, Rwanda, and then the International Criminal Court. And so I have to take you back, it's a bit of a history lesson really, to the 1940s and maybe even prior to that, to talk about why we have a Genocide Convention in 1948, but no Crimes Against Humanity Convention. Why did the international community, why did the United Nations agree to have a convention for the prevention and punishment of the crime of genocide, but nothing for crimes against humanity? Because that's really that's the gap that we're trying to repair, that we're trying to fix, is to create a convention for crimes against humanity that does the same thing as the Convention for the Prevention and Punishment of the Crime of Genocide. The Genocide Convention, I should add, deals with a number. It doesn't create the International Criminal Court. That's another business altogether. That happens, as I mentioned, at the end of the 1990s. But it provides for a number of obligations on states that sign up to the Genocide Convention, mainly an obligation that they should prosecute genocide within their own legal system. And that means they have to enact the crime of genocide in their criminal codes. They have to cooperate in matters of extradition and other rules, and they have to also participate in the prevention of genocide. And finally, they acknowledge that a dispute between states dealing with the crime of genocide can be adjudicated, can be judged before the International Court of Justice. So there are a number of important obligations that we have for genocide because of the convention, and we don't have them for crimes against humanity. At the International Criminal Court, there's no such problem, because the International Criminal Court allows for the prosecution of both genocide and crimes against humanity. It's really just up to the prosecutor to decide what to prosecute and to ask the judges, who then have to rule on this. But beyond that, the International Criminal Court doesn't make a meaningful distinction between the two. But at the level of the obligations of states, in terms of cooperating with other states and with the international community in the repression, the prevention, and the punishment of crimes against humanity, we don't have the same tool, the same instrument that we have for genocide, and that's what we're trying to address. And so I want to try and shed some light on why that situation has existed in the past and why it's time now to resolve it. If we go back to the time of the Second World War, very early on, by about 1941 or 1942, the idea had emerged that when the war was over, that the perpetrators of atrocities committed during the war were going to be brought to justice. And a very important declaration was made by the three leaders, by Churchill, Roosevelt, and Stalin, in October of 1943, basically serving notice to the Nazis that they would be held accountable as individuals for the crimes that they were committing and would be brought to justice. And this was a novel development in international law. It hadn't been done before. There had been hints of it at the time of the First World War, but it didn't really come to pass. And it just shows a progressive development in humanity, that we had got to the stage where war crimes were no longer going to be forgiven or amnestied or forgotten, or perpetrators put into exile like Napoleon, but instead they were actually going to be brought to justice. And shortly afterwards, the Allies agreed that they would set up a body called the United Nations War Crimes Commission. And it actually began work in London in early 1944. Now, the United Nations hadn't even yet been established, but they were using the term United Nations. I think it came from Roosevelt. It was something that, if we left it to Churchill, he would have called it the Great Powers Commission on War Crimes, or the Allies Commission on War Crimes. And it was just that Roosevelt was able to articulate a little better, to speak a little better to the people of the world, to speak more democratically. And he said, well, let's call it the United Nations War Crimes Commission. And the body started to meet. They brought together experts from many of the Allied countries in London. And very soon after they started to meet, the question became what actually was the substance of the crimes they were to prosecute. The idea of war crimes had ancient origins. You can go back to the time of the Greeks, to the Trojan Wars, and you find there's a notion of the laws and customs of war that have to be respected in an armed conflict. But, and that's, I think, what they thought they were going to prosecute. Now, the term war crimes itself is it's a bit odd because it's used in many different senses. And I think that if someone was to explain to someone on the telephone today about this meeting here in Chautauqua, they'd say, who was there? Someone might say, well, the war crimes prosecutors, the prosecutors from the war crimes tribunals. But while that's in a generic sense a good enough description, it's not quite true, because technically when we talk about the war crimes prosecutors, we talk about people who prosecute war crimes and genocide and crimes against humanity, and as we heard this morning, terrorism as well. So it's actually a broader concept. War crimes have a technical meaning, which means battlefield offenses, soldiers fighting dirty, essentially. That's the historic notion of it. And in a more modern understanding, crimes committed against civilians in the other territory, in the territory you occupy, the enemy's territory. But that's it. And what happened early in 1944 at the United Nations War Crimes Commission is that people started coming to the body saying, what are you going to do about the Nazi atrocities committed in Germany, about the persecution of Jews and of other minorities in Germany? And the answer that came from the foreign ministries of Britain and the United States, who were leading the debate, was, we're not going to do anything about that, because we're going to prosecute crimes under international law. And international law doesn't have anything to say about what states do to their own populations. That's their business. That's not a concern of ours. But over the course of 1944, in these meetings, that idea was gradually rejected. And what emerged was the idea, and I think it emerged simply because the unimaginable atrocities that had been perpetrated by the Nazis and that were increasingly being revealed in the course of 1944 as the tide of battle shifted, could not go unpunished. And even if they had not been adequately addressed by international law previously, and certainly not adequately defined, that they had to be prosecuted. And by the end of 1944, I think that corner had been turned, and it was well accepted that in some way the post-war prosecutions were also going to deal with atrocities committed against any civilian population. And I use that term very intentionally, because you'll see it reappears in the definition that is adopted at Nuremberg of crimes against humanity. And it's in the definition that we use today. Any civilian population, including your own. And that's the idea of crimes against humanity. But they don't use the term crimes against humanity in 1944. I think there are a couple of suggestions that it be used, but generally when they write it down, the expression that they use is atrocities, persecutions, and deportations. So they'll prepare in the various drafts of the United Nations War Crimes Commission lists of the crimes, and they'll have war crimes, and they'll have a list of them. They add another category called crimes against peace, and that was the subject of our Chautauqua days last year, what we today call the crime of aggression. And then they had this third category called atrocities, persecutions, and deportations. And clearly they were struggling with how to define this phenomenon of the atrocities committed by the Nazis, and in particular those committed within the borders of Germany itself and directed against minorities. At about the same time, other people outside of the Commission, not involved with the Commission, are laboring on much the same problem. And the most important of them is an individual who has fled from Nazi-occupied Poland, a Jewish-Polish lawyer named Raphael Lemkin. He makes his way first to Sweden and then to the United States. He gets a short appointment at Duke University and then eventually gets another adjunct appointment at Yale University and starts working for the US government on the war crimes prosecution problem. And in the meantime, he prepares a book in the course of 1944. It's published in November by the Carnegie Foundation. It's called Axis Rule in Occupied Europe. And in that book is a chapter of about 30 pages called Genocide. And that's the first time the word genocide is ever used. And he has invented it. And he's invented it to describe in his own way the phenomenon of atrocities, persecutions, and deportations, to use that expression, atrocities perpetrated by the Nazis against minorities, including those within Germany itself. In other words, he's trying to address the same problem. He comes up with a slightly different paradigm, a slightly different definition, and a slightly different name. He calls it genocide. And in the chapter, he talks about a range of acts of genocide that include various forms of persecution of minorities, not just their extermination, but various other forms designed to aimed at attacking the minorities with a view to their eventual disappearance. The next stage in this process is an important conference that takes place in London in June and July and early August of 1945, called the London Conference. And the London Conference is where the great Nuremberg trial is prepared. One of the leading individuals at that conference, everybody knows his name, and he practiced law originally just down the road from here in Jamestown, is Robert Jackson. Robert Jackson was sent by President Truman to negotiate the terms of the Nuremberg trial, how that would take place. And so Jackson goes with this material. He has the definition of atrocities, persecutions, and deportations that Lemkin that has emerged from the UN War Crimes Commission. And he also has the work of Lemkin. In fact, he has Lemkin with him because Lemkin comes to advise in London, and he's there to assist him. And Lemkin's there sort of pumping for his word. He wants genocide to be used in the document that they're going to use for the prosecutions at Nuremberg. The conference lasts several weeks, and the final weekend, I think, before the end of the conference, Jackson goes to visit a very distinguished law professor, the chair in international law at Cambridge University, who Jackson had got to know when he was Attorney General of the United States, because this famous professor had come to lecture in the US and had gone to meet with Jackson, and his name was Hirsch Lauterpacht. Ironically, Hirsch Lauterpacht is rather like Lemkin. He's a Jew from Eastern Europe who has also kind of fled. I mean, he emigrated really from there, but by that time there was no question of him ever being able to return, and like Lemkin, many members of his family perished as well in the Holocaust. And Lauterpacht came and became the most distinguished professor of international law in Britain by that time, by 1945. So Jackson goes to visit him over the weekend in Cambridge. They have dinner at Trinity College, where Lauterpacht is a fellow. And as Jackson later reports to the conference, he said, he had this great suggestion that instead of talking about atrocities, persecutions, and deportations, that we call the concept crimes against humanity. And that's where we first see the term, and it's adopted. It's agreed to by the other members of the conference. Now, Lauterpacht didn't invent the term. Lemkin invented the term genocide. But Lauterpacht didn't invent the term crimes against humanity. We know, and the writers about it, if Sharif Bassiouni was here today, he was originally scheduled to be on our podium, he would remind us that it was used initially, at least in an international political or legal sense, in a famous declaration made in 1915 by the Russians, the British, and the French. And I quote from the declaration, it was a message to the Turkish government about, quote, these new crimes of Turkey against humanity and civilization. And I think until very recently, when we taught crimes against humanity, we would say that's really the first citing of the term. I found a couple of sort of anecdotal uses of crimes against humanity even prior to that point. And it is of not just of historical interest, but I think of legal interest as well, in responding to the argument about retroactive use of the term. We'd like to be reassured that actually when the term crimes against humanity was used even in 1945, that people knew what it meant, that they were familiar with, if not the legal definition of it, what the concept reflected. And we knew of one use by an American journalist who went to the Belgian Congo in the late 1890s, and that's about where the trail grows cold. Last year I found a unique and original and new research tool that enables you to trace the origin of an expression. You know that if you want to know the origin of a word like crimes, you can go to the Oxford English Dictionary, the 20-volume dictionary, and you can see all the use of the word crimes in the English language, or humanity, and you can do the same thing, but you can't trace the expression. And I discovered this new research tool, which is called, many of you actually know it, Google Book. And I had my assistants put in quotes, crimes against humanity, crime against humanity. We did it with different languages as well. And we found the term was used frequently through the 19th century and well into the 18th century in different languages, in slightly different forms, but that it was a familiar term. It was often used to describe slavery and the slave trade. And the very earliest citing of the term crimes against humanity, which I think is almost poetic, is Voltaire. So he invented the term, Voltaire, crimes against humanity. It seems, at least that's my story, and I'm sticking to it until someone finds an earlier. That's what Google Book reveals, is that it was Voltaire who used the term. And so Louderpact, to get back to our story, Louderpact in 1945 is actually using a term that is familiar to people. But he says that's what you should call it. Now there's one other little difficulty, and this is really the central part of our problem and why we have a Genocide Convention and not a Crimes Against Humanity Convention. There's a debate at the London Conference, and Jackson writes about this in his report on the Nuremberg trial to the President of the United States. He said, we had a difference in opinion about the lawmaking process at the London Conference. The Russians thought that we were making law that was only going to apply to the Nazis. But he said, I was always of the view that we were making law that was going to apply to us as well. And that what we were doing when we were defining these crimes was defining a body of law, crimes that for which we could also be held accountable. And you see the debate then, and that colors Jackson's speeches at the London Conference. And it also influences the definition. And there's a point where he says, we have to be very careful when we recognize as an international crime the responsibility of a government for the persecution of its own citizens. And he says, because we have in our own country manifestations of the persecution of minorities, and we don't want to be held accountable at international law for that fact. And of course, Jackson was speaking about the treatment of African Americans in the United States at the time when there was a system, an apartheid-like system, at least in certain states, still the practice of lynching in southern states in the United States. And obviously, as a Roosevelt Democrat, it's not something that Jackson is proud about, but he has to defend his own government, and he has to be realistic about what he's going to accomplish, and he has to protect his own government from being exposed to prosecution for crimes against humanity. And so Jackson says, I think what we ought to do is restrict crimes against humanity to these acts of persecution of minorities committed in association with the aggressive war. That way, he knew that the Nazis could be found guilty, but that his own government and his president and himself and others could not be held accountable or prosecuted in the same way. And so crimes against humanity was born as a legal concept, defined at Nuremberg, but limited by this restriction of the association with the war. I always think I would have loved to be a fly on the wall at that conference, because in the report we only have Jackson talking about his concern, quite honestly and quite candidly. But I wonder I could just imagine the British guy at the conference thinking, that's a good point, and what about India and Nigeria and Cyprus and Aden and Palestine and Jamaica, and then the French guy sitting there scratching his head saying, yes, and what about Indochina and Algeria and the Congo and all of their colonies, and then the Russian guy, he was actually Ukrainian, but he's sitting there worrying about atrocities committed by all four of them, finally. The Soviets, the British, the French, and the Americans have got big things to worry about. And so they wanted a final law that they'll use against the Nazis, but that won't come back and bite them in the tail. And that's what they do. And the judgment is upheld. That approach, that analysis of crimes against humanity is upheld by the judges at the end of September and the beginning of October 1946 in the Great Nuremberg Judgment. And then a very interesting development happens. Immediately after the judgment, our friend Lemkin, remember him? Raphael Lemkin, genocide, he's still there. He's hanging around. He's been lobbying to get them to put the word genocide in the judgment. He doesn't succeed. He gets the prosecutors to use it a little bit. And he's furious when the judgment comes out, not, I think, because they don't use his word, but because of the consequence of limiting crimes against humanity, which he finds to be profoundly hypocritical and disturbing. And I learned about Lemkin's personal reaction from a person who's also been mentioned here today, Henry King. Michael Scharf had the book of Henry King, comments about Henry King that he gave to the speakers this morning. Henry King was one of the younger prosecutors at Nuremberg at the time. He passed away, 3 years ago, Michael? 2.5 years ago. And Henry King described how he met Lemkin in the lobby of the Grand Hotel in Nuremberg. It's still there, by the way. It's a grand old hotel. And he met Lemkin there, and he said he was disheveled, he was distraught, and he was furious because he said the Nuremberg judgment had agreed to prosecute wartime genocide, but not peacetime genocide. He said the crimes the Nazis committed before 1939 went unpunished. They're mentioned in the judgment, but nobody's convicted for them. And Lemkin was furious, and he said, I'm going to fix this. He rushes back to New York. He goes to the General Assembly of the United Nations, which is meeting for the very first time in an old factory in Lake Success on Long Island. And he starts lobbying. And he's never done this really before, from what we can tell. He's been an academic, and he was a practicing lawyer in Poland. But he converts himself, transforms himself into a campaigner at the United Nations. And he convinces 3 delegations, Panama, Cuba, and India, not the great powers, not countries that are afraid of the atrocities that they're committing against their subject populations, but countries of what we would later call the Third World, who are afraid of being persecuted, essentially. And he says, let's see if we can fix this problem. And he says, let's have a resolution that we'll call the Resolution on the Crime of Genocide. And let's recognize genocide as an international crime that can be committed in time of peace. And when the Cuban ambassador to the UN stands up in the fall of 1946 to present the resolution, he says, we're here to fix the problem with Nuremberg. We're here to fix the shortcoming of the Nuremberg judgment. We want to recognize these atrocities can be committed in time of peace. And the resolution, which is adopted in December of 46, calls for the adoption of a convention on genocide. And they proceed to negotiate that. And it's adopted, as I said, in 1948. Now, the difficulty with it is that the 4 great powers who agreed to a lawmaking concept in 1945 for the Nuremberg trial by which the Nazis could be charged with crimes against humanity, that is, atrocities, persecutions, and deportations of their civilian population committed in wartime, are not going to turn around 2.5 years later and do the opposite. They're not ready for that. The same difficulties they had in 1945 exist in 1948. And essentially what they say to the UN is, we'll agree to a concept of international crime committed against vulnerable civilian populations, against minorities, that can be committed in peacetime, but you're going to have to narrow it. You have to narrow it a lot. And that's what they do. And they narrow it, they call it genocide. They don't mention crimes against humanity. It's separate, it's different. But actually, it's all the same. It's born in the same, it's forged in the same crucible, if you want, genocide and crimes against humanity, to address the same reality, the same Nazi atrocities, but it gets a different definition. And it's defined as acts intended to destroy national, ethnic, racial, or religious groups. So it's narrower in two respects than crimes against humanity. It's confined to national, ethnic, racial, and religious groups. Doesn't cover political groups, doesn't cover social groups, doesn't cover a range of groups or individuals who might be covered by it. Doesn't deal with any civilian population. It has to be one of those four groups. And moreover, it has to involve the destruction of the group and not just the persecution and the deportation. It's narrower than atrocities, persecutions, and deportation. It has to be the destruction. And so the four great powers and other countries say, we can agree to that, so let's have a convention. And that's where the Genocide Convention comes from, 1948. It's a result of the same phenomenon, but it's much narrower in some respects than crimes against humanity. Broader in one important respect, because it says at the very beginning of the Genocide Convention, this is a crime that can be committed in time of peace as well as in wartime. So that problem is solved, but for a much narrower definition of crime. And for about 45 years, we live with this tension, if you want, between crimes against humanity and genocide. Every time there's an atrocity, in the 1970s, when the Khmer Rouge are committing their atrocities, that's the subject of the tribunal where Andrew Cayley is the prosecutor, one of the prosecutors. People come to the international lawyers and say, well, what can we get them for? I say, well, what are they doing? Well, they're attacking people, they're persecuting them, they're killing people. On what ground? Well, kind of on political grounds. It's mainly because they disagree with their political objectives. Is there a war on? Not really. It's kind of peacetime. It's kind of settled down. And they say, no, that's too bad, because then we could get them for crimes against humanity. But maybe we can stretch the definition of genocide. We'll say that actually genocide doesn't just cover national, ethnic, racial, or religious groups. But we had a big hole. We had a big impunity gap in the law between crimes against humanity and genocide. And in the 1990s, when international criminal prosecution revives, that hole suddenly gets repaired, at least in some respects. It gets repaired because the International Criminal Tribunal for the former Yugoslavia, in its first judgment, says crimes against humanity can be committed in time of peace as well as in time of war. And that idea, which was revolutionary in the 1940s, is well accepted by the 1990s. And when the International Criminal Court statute is adopted in 1998, that's agreed to, that's accepted. And so the hole in the definitions of the crimes is repaired. Now, over the years, some people had argued that really what we should do is enlarge the definition of genocide to fill the hole. Well, we could have done that. I don't quite know why we didn't. Instead, we enlarged the definition of crimes against humanity. But one way or the other, that hole got filled. And so when the International Criminal Court was established, we have these two concepts, crimes against humanity and genocide. Crimes against humanity is much broader than genocide. It's kind of like killing. It's kind of like manslaughter. And then you have premeditated murder, which sort of fits inside crimes against humanity. some people say, well, actually, they have different objectives, the two crimes, but I think that's maybe exaggerated, because when I look back at the history and why they were created, I think they were both created to address, but in different ways, and solving different problems, the same phenomenon. And so, by 1998, the problem of the definition is solved, and we also have a court, the International Criminal Court, that can prosecute for either crime, or for both. And you can charge people for both genocide and crimes against humanity. Doesn't really matter very much. The sentence can be the same. It's a choice that the prosecutor will make and that the judges will make. But we still don't have our convention for crimes against humanity. And that's a gap, and maybe it's not a huge gap, but it's an important one. There's a lot of symbolism about it, because it consolidates and confirms this achievement of fixing the problem with crimes against humanity that Lemkin ranted about in 1946, and that launched him on his process of promoting the crime of genocide. And I think that maybe this is the last piece in doing it, and that's the initiative that Leila launched 3 years ago, and I had the privilege to be brought into it at an early stage with a number of others, some of whom were scheduled to be on our panel, like Hans Karel and Sharif Bassioni, and who are not here, and others like Richard Goldstone and Christine van den Weingart and Juan Mendez, and have I named them all? You'll show them all on the slide as well. So that's the introduction, and Leila very kindly introduced me, and she says that I'm to introduce her, but I don't have assistants here like you do, Leila, to prepare little notes for me. And all I can say is that Leila is a very highly regarded scholar in the field of international criminal law, who I think began studying, actually her doing as a postgraduate student and working as a lawyer in Paris, where she followed some of the post-war, well, long after the war, but they were Nazi prosecutions in France of Touvier and others, and wrote about that, and then returned to the United States, where she's published a great deal and was at the Rome Conference of the International Criminal Court, and like many of us was also more recently at the Kampala Conference, although I don't think you made the whitewater rafting trip down the Nile. We have a group of us here, and if Michael Scharf has the video, we could actually show it, but there are several veterans of a legendary journey down the Nile River over waterfalls, and there are 4 or 5 of us who are here and live to tell the tale. But you haven't told me when my time is up, and I sense that it's up. And so thank you very much, and over to Leila, who's the main act.
We'll see if we can get, Shishir, can we put it down a little bit more? Thank you so much, Bill. And the PowerPoint's on now, right? Okay. For that really magisterial, historic description of where we were and where we might go. So I will take it from here. We are now in 2011. So we are 63 years after Jackson's opening statement at Nuremberg, and François de Monton's stirring pleas to the judges at Nuremberg, talking about crimes against humanity, or crimes contre l'esprit. And one of the things that I learned, I was recently coming back from Paris, where I just spent time on sabbatical, was you're indeed correct. There is a ton of references to crimes contre l'humanité, or crimes against humanity, in the French literature in the 1830s and 1840s, talking mostly about American slavery. So it does have an historic pedigree in that sense. So let me talk now directly about the Crimes Against Humanity initiative. And the premise for the initiative, I hope you can all see the slides, but I'll describe them as I speak, is that essentially, as Bill just described, we have a gap in international law. I might argue that it's a pretty significant gap when one thinks about it, that we still have a widespread and systematic problem of crimes against humanity, which of course was the title for our conference, that existing international legal instruments failed to close the gap, and we proposed to close it. And just, I don't want to repeat myself here, but this is the Article 6C. This is the charter that Bill just referred to that talked about crimes against humanity. And crimes against humanity also appear in a sense, but in a nascent form, in the 1907 Martens Clause. That was a clause in the preamble of the Hague Convention of 1907 that says until a more complete code of the laws of war is issued, the high contracting parties deem it expedient to declare that the inhabitants and the belligerents remain under the protection and the rule of the principles of the law of nations as they result from usages established among civilized peoples, from the laws of humanity, and from the dictates of the public conscience. And the idea was that outside the four corners of the treaty, there were these laws of humanity, of civilization. And after the war, we got a little bit of codification. We got Raphael Lemkin's extraordinary effort to get the Genocide Convention. There's also a couple of what we could call crimes against humanity-like conventions, which is apartheid, torture can be a form of crime against humanity, and more recently, enforced disappearances. Bill already told you about the Genocide Convention, and it's limited, as he said, to the intent to destroy, in whole or in part, a particular racial, ethnic, religious, or national group. And you heard the presentation of Prosecutor Cayley this morning. Cambodia's killing fields was perhaps one of the most cases in which we wanted to call it a genocide, because that's what it felt like. It was 1.7, I think he said 1.8 million out of a total population of 7 million. But unfortunately, under the legal definition of genocide, most authorities would say that for all the compelling moral case, a legal case could not be made. And this, I think, I don't know if Andrew's here, but this, I think, these are the pictures that he was talking about at the prison. The Bosnian versus Serbia case is another case where we saw this confusion between is it genocide or crimes against humanity go into become essentially a legal problem, because the jurisdiction of the International Court of Justice is limited to cases in which you have a jurisdictional clause in a treaty or the states agree. And the only agreement in the case was the Genocide Convention. And so other than Srebrenica, all the crimes that were committed, 100,000 deaths, 50,000 rapes, 1 million displaced by some estimates, fell outside of the jurisdiction of the court. And so this slide is maybe one of the most important in terms of grounding. What are we talking about? What are the prosecutors doing in their work at these international tribunals? We still have, sadly, a wide impunity gap. Sharif did a study, one of my steering committee members for this initiative, and again, it's very hard to get accurate numbers, but his study showed 313 armed conflicts between 1945 and 2008, which with an estimated death toll of 92 to 101 million civilians, or of people, most of whom were civilians. Crimes against humanity also covers, in addition to extermination, which genocide covers, sexual violence, enforced disappearance, forced displacement, and deportation. And if you think about the large numbers of perpetrators of these offenses, the estimate that Sharif came up with in this study was that fewer than 1% have been brought to justice. So the tribunals that you heard from this morning all have crimes against humanity, except for the Special Tribunal for Lebanon. And I'm sorry, Daryl, that one's not on my slide. They all have crimes against humanity in their statute, but because we didn't have a treaty on crimes against humanity, the definitions tend to be different in all the different courts, because they had to rely upon what we thought was a customary international law definition. And finally, repeating a little bit what Bill said, in 1998, in the 5 weeks and of course in the many, many years prior to the negotiation of the Rome Statute, we finally got 165 governments to sit down and authoritatively negotiate a definition of crimes against humanity, which was then placed into the ICC statute and has become the first treaty definition, really, of the crime. Now, why not just stop there? So haven't we fixed the problem that Lemkin's Genocide Convention left with, because we now have the ICC? And certainly when the ICC was adopted, it was an extraordinary achievement. And most of us, I was at Rome, Bill was at Rome, I know many of you were there, Ambassador Sheffer led the US delegation. I don't think we all believed it was really going to happen. It was such an extraordinary moment in international criminal justice. And the applause, the excitement on the last day of the conference was something really absolutely unforgettable for those who were there. And why not just stop there? Well, the reason not to stop there, of course, is that it's all incremental progress, and the Rome system itself has certain gaps. So there is a definition, but we still don't have what we call state responsibility, and that ties in maybe a little bit to Ambassador Sheffer's talk this morning, which is we have a civil system as well as a criminal system now in international law. And the civil, that is the reparations, the monetary damages, the ability to sue a state, saying your state committed crimes against humanity, which is important because there is a collective dimension to these crimes, is not fixed, right? The ICC statute only covers individual criminal responsibility. There's no interstate enforcement mechanism, so there's no extradition, there's no mutual legal assistance, there's no provision for transfer of evidence. The ICC is a vertical system, it's not a horizontal system. So you have 193 sovereign states in the world, you have an international criminal court at the center of that system of international criminal justice, but with a vertical relationship to those states. You need to have those states have relationships with each other. And of course, the Rome Statute, importantly, doesn't bind non-state parties or have jurisdiction over legal entities. So we love this picture. I'll explain this picture in a little while, but you can see the very first meeting, April 14th, 2009, of the Crimes Against Humanity Initiative. And here I have to pause because I wouldn't be where I was at, or none of us would be without the work of the Nuremberg prosecutors. And at the top, you can see Whitney Harris, and yeah, brings a little tear to our eyes, Anna. But Whitney actually was very, very supportive of this initiative. He was on Justice Jackson's team at Nuremberg and had brought the first Crimes Against Humanity case along with the others. And we decided to study the issue of could we fill this gap. And I have to credit Sharif also, who had written a little article in 1994 saying, gee, why don't we have a Crimes Against Humanity convention? And I remember reading that article. You know, I was just entered law teaching, and I was very dutiful. I read everything there was to read, and my research assistants photocopied it, and I thought, that's a good point. And then in 2008, I thought, yeah, why don't we have a Crimes Against Humanity convention? And I called Sharif, and Sharif said, let's write one. And I said, well, I'll do it if you're on board. And Sharif, thank goodness, said yes, because as you know, he chaired the drafting committee for the Rome Statute for the International Criminal Court. And then I called Richard Goldstone, another good friend of the Harris Institute, and said, Richard, what do you think? He said, great idea. And then I was lucky enough that Bill Schabas, the leading authority on the crime of genocide, the leading authority, even though he's too modest to say it, said yes. We reached out to Christine van den Wingert, who had authored a very important dissenting opinion in Congo versus Belgium, an ICJ case, and was also at the time, I think at the ICT, no, she'd gone over to the ICC at the time, but a sitting judge of the International Criminal Court, Hans Karel, who is supposed to be here today, but who promises he'll come next year, the former UN Undersecretary for Legal Affairs, and then Juan Mendez, who was the former UN Special Rapporteur on Genocide. And interestingly enough, the United Nations didn't even make that title Genocide and Crimes Against Humanity. It's just genocide. And so we created this Crimes Against Humanity initiative. We started to meet, we started to say, how can we proceed to study a question as broad as this? There have been expert undertakings like this in the 1920s. The International Association of Penal Law and the International Law Association produced draft statutes for an international criminal court. Of course, they didn't see the light of day until 1998, and we hope we'll be a little faster, but there is this precedent, if you like, of this push coming from outside of governments. And so we had a meeting in St. Louis, we commissioned expert papers, and we started the drafting. And Sharif circulated a first draft. We had a lot of people ripping it up. Some of the people are at this meeting, actually. We had papers from Mike Scharf and Mike Newton. David Crane wrote a wonderful paper. Mark Drumble came and poked all of us. Diane Amon had comments, Betsy Anderson. A lot of the people who are here today were at this first meeting. And then we held a second meeting in The Hague, and a lot of these pictures on the top are sort of pictures of the working meetings of the groups. And then we had a second meeting, we did more revisions. We had a technical advisory session in St. Louis in 2009 where we basically didn't really start from scratch, but we took all the comments and we started really reworking the contours of the treaty. And then we drafted, we finished it, translated it into French so we could have it in 2 of the 6 working languages of the United Nations and circulated it. We then convened a conference at the Brookings Institution. We had 100 people at this conference, so all told, we had about 250 experts participating in this. Ambassador Stephen Rapp gave a wonderful speech. And there was some skepticism. Do we need another treaty? How could we do it? It's so complicated. We don't want to hurt the ICC, and we understood all those considerations and spent a lot of time really trying to meet them in the final text that we adopted. So in May 2010, we had a small meeting in Chicago. We finished the convention. The steering committee then revised and adopted it. We translated it into French. And now we are in what we call phase 4. And I don't think phase 4, I don't think we're a third of the way through. I think we might be 1/10 of the way through, in the sense that the most easy, in a sense, even though it was difficult, was production of this book and the treaty itself. It involved about 250 people over 3 years, but it was technical work, in a sense, that we're all well equipped to do. The difficulty now, of course, is the political process. So let me talk just a few minutes about what's in the treaty and then maybe throw it open. I don't know if we'll have time for questions or not. This is an excerpt from the preamble. The preamble rests very much, it's very much like the Rome Statute for the International Criminal Court in that essentially it evokes what's the sociological case for this treaty. It's that we have an impunity gap. And we need states to pick up the slack in doing this. And think about the wonderful panel we had this morning with all those prosecutors talking about how their courts are about to be closed. And how are we going to have the ICC handle all these cases in the future? States are going to have to pick up some of the slack, and states are going to have tools to do this. So this is Article 1, crimes against humanity, whether committed in time of armed conflict or in time of peace, which harkens back to the Genocide Convention, constitute crimes under international law for which there is individual criminal responsibility. In addition, states may be held responsible for crimes against humanity pursuant to principles of state responsibility for internationally wrongful act. This would be the first time that an international criminal convention clearly sets out a principle of state responsibility. States may strike, if they ever start negotiating this might be the first sentence that gets deleted. But, what the heck? We put it in there because in Bosnia versus Serbia, the ICJ said there is state responsibility under the Genocide Convention. States have a duty to prevent, except the presiding judge of the court disagreed with that. So we thought it was important to spell it out. And then Article 2, it's a classic international criminal law instrument, talks about the object and purpose of the convention to prevent and to punish, and sets out obligations for states. The convention has now, as finished, that is, this is a proposed draft, contains 27 articles, 6 annexes, and it has a Martens Clause, because we recognized during the drafting that the minute you codify something in a treaty, you essentially freeze it. And we wanted the law to be able to continue to develop in states, because states may adopt this convention, or like they did the Genocide Convention, may decide to be more progressive in their elaboration of the elements of the crime. And so Canada, for example, I think, Bill, I'm correct, has a broader definition of genocide than is in the Genocide Convention, and that's true of Spain as well. So this convention, in a sense, sets a floor, but it doesn't set a ceiling for what states can do. I also want to recognize Diane Amon, because something she said at our very first meeting in St. Louis really resonated with me and with the other members of the steering committee, which is the beauty of the Genocide Convention is its simplicity. you can read it and you say, I can figure out what genocide is, right? It's extermination. It's this intent to destroy. And the difficulty with crimes against humanity is it's really complicated. The definition is very long. It's somewhat turgid. And when we wrote the convention and started putting in lots of provisions, the convention itself became very opaque. And so in order to make it a little bit more transparent, a lot of the important dispositions of the convention that deal with interstate cooperation, extradition, transfer of evidence, et cetera, are in annexes to the convention. It builds upon 4 pillars, and I'm just gonna not spend too much time on this because it's been a long day. But essentially there's the normative case for the convention, there's the prevention dimension, which is very important, there's punishment, and there's capacity building. And I just want to say one word about prevention. One of the things that we've really seen crimes against humanity start to emerge as, in terms of the importance of the work that the international tribunals are doing, and especially the ICC, is we see crimes against humanity because it doesn't require a war, and because it doesn't require the bad guys, right, the perpetrators, to be going so far as extermination, to have a certain preventive dimension. So in Libya, it was the only thing the prosecutor could charge at the time. It wasn't yet a war, and there wasn't a genocide. In Syria, I would argue, we have a situation of crimes against humanity. We don't have armed groups fighting with each other. We have mistreatment of a civilian population rising to the level of severity that I would say was widespread or systematic. So crimes against humanity from that perspective are really important if you care about prevention. So I just wanted to go through a few of these because sometimes I get a question from the specialists, what does this convention do that we don't already have? And so here's sort of my list of 25 things that I would say. You obviously have state responsibility combined with a jurisdictional clause in the International Court of Justice, not something we would even want in the ICC statute. Imposes duties upon states to prevent, investigate, and punish. And that's one where sometimes I get pushback from Rome Statute state parties who say, well, we have a duty. We have a duty to punish. It's in the Rome Statute. Actually, the Rome Statute doesn't impose a duty. It's implicit because states agree in the preamble that states have the duty to punish international crimes, but there's actually no obligation to do so. It codifies a very important point, which is that if a perpetrator of crimes against humanity arrives on your territory, do you give them exile? No. You have an obligation to either pursue them yourself as a government or to extradite them to another willing state. You also have a problem in some states with respect to statute of limitations. Statute of limitations, which I don't have on this slide, but statute of limitations can be a serious problem with crimes against humanity because many states, if they don't have an incrimination, and only about 44 states I think do now, will prosecute for murder, and many states have a 10 or 20-year statute of limitations on that. And crimes against humanity, at least in the Rome statute system, are imprescriptible. That is not true in all national legal systems. And it's a bit tricky because some national legal systems have statute of limitations for war crimes. And so this makes a point about crimes against humanity being imprescriptible. There's also a provision for reparations. Monetary damages can be very important on collection of evidence. There's an extradition treaty that's essentially annexed to the treaty, that's part of it. A mutual legal assistance treaty, a transfer. This is very technical, but this is basically the way one sovereign state helps another sovereign state conduct a criminal case across borders when there's no international intervention. There's the idea of a treaty monitoring body that's there in order to induce compliance, because you don't want a treaty full of sticks, you want some carrots. Many people suggested have a voluntary trust fund, have a treaty monitoring body, have a way that lesser developed countries can participate, can engage in capacity building, educational programs, and get the money to do so. So right now we're in phase 4, as I said. We've just published a book. The treaty is available in French and in English. It's also on our website for free, I should say. We have a few copies of the book here if anybody wants to get the book. It has some wonderful papers. I think Ambassador Sheffer, David, you're also in the book on responsibility to protect. There are a lot of really wonderful, very thoughtful essays by people who are here. And we're engaging in, how should we say, education. So I just wanted to pause with a couple historic notes, and then if we have time, we'll take some questions. I don't know where Greg is. When we started this project, and it was a big project, I didn't realize how big it was, or I might not have started it. But it was an idea that resonated with those of us who were in St. Louis, who knew the history of Washington University School of Law, because 105 years earlier in Ridgely Hall at Washington University, during the convening of the 1904 World's Fair, the Interparliamentary Union met, and they issued a resolution asking President Roosevelt to ask the Tsar of Russia to convene a second Hague Peace Conference. And so the very famous 1907 Hague Peace Conference actually originated from a building on our campus. We're very proud of this, although very few people other than me and a few others know this. And so on your left, you have a picture of the gathering of 1904 in Ridgely Hall in 1904, and they issued this resolution. And then sitting in exactly the same place 105 years later, you have the very first experts meeting of the Crimes Against Humanity Initiative. And finally, because we're at Chautauqua, and we owe so much to our Nuremberg prosecutors who have come before us, because we're all standing in the shoes of somebody else. I'll just leave you with a quote from Whitney Harris, who was very supportive of this effort, and I'll read it for those of you who can't see it. "The challenge to humanity is to establish and maintain the foundations of peace and justice upon the earth for centuries to come. We must learn to end war and protect life, to seek justice and find mercy, to help others and embrace compassion. Each person must respect every other person and honor the God who made this incredible mystery of human life a reality." Whitney R. Harris, former Nuremberg prosecutor, June 12, 2006. Thank you. Here we go. And that's the website if anybody wants to copy it down.
I'm always inspired by my colleagues and friends and the incredible work that they're doing, and this is just another example of the quiet but important work that's going on, and you should feel very, very heartened. I'm always humbled when I come to the dialogues at this incredible effort that all of us, particularly my colleagues, are doing, and on this one, my kudos to both of you and other members of the experts committee. Well, I'm going to invoke it's a very nice day rule. And part of our dialogues, the important part of the dialogues, is the ability to take breaks, long breaks, and to go out on the porch, to move about, to talk to colleagues and friends, to further the discussion on many things that we've considered today. I do want to remind you, though, there's more. And so let me just go through this really quickly, or Greg Peterson and Carol Drake could be mad at me. So at 5:30, of course, we have a reception in the lobby. It used to be 6, but it always seemed to start around 5:30, so we're going to give in and we're going to start it at 5:30. Go figure. Then we'll have our dinner here. So we kind of have to move anyway because we have to have our wonderful support staff be able to get the room ready for dinner. And then something I really want to highlight, we're very excited about this because this is the first time. At 8 o'clock, we're going to hold the first annual Catherine B. lecture. This is something that the Executive Committee of the International Law Dialogues thought was very important, and something that we're going to now permanently put in the Monday time slot right after dinner to continue to honor the very important role that women have played in the development of modern international criminal law. And Catherine B. Feit, who we'll talk about tonight in detail, was one of the first who led us into modern international criminal law. And I think it's very right and proper that we have our good friends from International Girls, many of which are here. I don't know where that came from, but I do have very happy to have them as our sponsor. Maybe Professor Diane Marie Amon will tell us about where that came from. But they're also a very important part of our dialogues, and she'll be giving the first Catherine B. Fite lecture this evening right after dinner. And of course, we also have a very important second day, and I'll just highlight very quickly so that we're all kind of oriented. Obviously, in the morning, we start having breakfast at 7 o'clock, and this is your opportunity to have breakfast with the prosecutors, the wonderful practitioners, and members of the Academy here to talk about many of these issues. And then at 9 o'clock, we're going to have an update on international criminal law. It's become quite a tradition where we have one of our distinguished colleagues this year, the Professor Beth van Schaak, who will be just giving a reflection on update on international criminal law over the past year, and a busy year it has been. During this time frame, the prosecutors will move off to a secret location where we'll finalize where we have been working very hard on the drafting of the 5th Chautauqua Declaration. As you recall, we issue a declaration each year highlighting various issues of concern by the prosecutors. And so we're going to finish our final drafting of that declaration, which we will then sign before you tomorrow afternoon at 2:30, where we'll formally issue the 5th Chautauqua Declaration. Of course, there's something going on between. One of the things we started last year was we have porch sessions. And so we're going to be breaking down into groups, and we'll talk more about that tomorrow as to what's going on as far as where you can go. But the areas that we're going to be talking about this year is the Charles Taylor case, which is about to come to an end. We also are going to be talking about Gaddafi and the Middle East. And then we're also going to be talking about, because it's right and proper, in the 10th anniversary 9/11 retrospective. And we have key members of our the Academy are going to be moderating those discussions. And you're free to pick and choose where you'd like to go. It'll be easily marked on the porch. Grab a rocking chair, a comfortable chair, and sit around with all of us, and we'll be talking about those issues. Yes, there will be one Fletcher event, and that will be our review of international criminal law with Professor van Schaak. And what's that? I believe it is. Greg, is that correct, or is it here? And the signing will be also at Fletcher. Thank you. But we'll get more into that. I will turn it over to Greg, who has other details.
Hey, how about this David Crane? Isn't he something special? That's all he wanted me to say. That was it. There's that song, I'm some kind of wonderful, something like that. But really, David, I said it before, I'll say it again, and it's worth repeating. He's the inspiration, the perspiration, and the real follow-through type guy for this event. Otherwise, it would not have happened. With regards to, just again, the logistics, we have Fletcher Hall, 9 o'clock tomorrow, then Athenaeum, 11 o'clock, Athenaeum lunch, Athenaeum keynote speech here, and that's at 1:30, and then 2:30, due to a lot of reasons, very positive ones, we're going to go up back to Fletcher, and that's where we'll have the Chautauqua Declaration. That's at 2:30. That's when they'll be reading it, signing it, and then it'll become the permanent part of this particular, and the conclusion of the International Humanitarian Law Dialogue. So, recap. Breakfast here, 9 o'clock Fletcher, 11 o'clock here, keynote speech here, lunch, keynote speech here, and then we go back to Fletcher. It's all on this sheet. Nothing's changing. With that, we stand adjourned. Thank you.
be great.